Section 20, Property Management.
The Alabama Uniform Residential Landlord and Tenant Act of 2006 covers residential landlord-tenant relations in Alabama. To evict a tenant, legal notice has to be given, and a judge decides whether eviction action is appropriate. Property management, that's a professional service to maintain and manage property on behalf of owners. It involves leasing, managing, marketing, and the maintenance of property. Leasing and property management. You have basic property management concepts and duties, lease agreements, landlord-tenant rights and obligation, property managers' fiduciary responsibilities, and ADA and fair housing property management compliance. When it comes to tenant representation, as far as contracts are concerned, we act as a single agent of the owner in all aspects of management of owner's investment, meaning if we're the property manager. The basic concepts and duties in property management is to achieve the objectives, generate income for the owners, and preserve and/or increase the value of the investment property. What are the rights and obligations of landlords and tenants? The landlord and the tenant both must meet health and building codes. The landlord needs to provide heat and running hot water, insect extermination, garbage receptacles and pickup, as well as working smoke detectors. The tenant needs to use reasonable care in the operation of the equipment and not disturb the peace of others. Let's talk about leases. A lease is a contract between a lessor, the owner of real estate, remember your Ors and Es, Ors give, Es receive. So the lessor is your landlord, and the lessee, the person receiving the property to live in, is the tenant. It transfers possession and use of the property and lasts for a specified period of time and is made in return for consideration, possession, payment. The statute of frauds in most states requires that leases for more than 1 year be in writing to be enforceable. The lessor has a revisionary right to possession of the property when a lease expires. A valid lease requires parties with the capacity to contract, legal objectives, offer, acceptance, and valid consideration. You can remember it by the acronym above, COLAC. A lease typically includes a description of leased premises, implied covenant of quiet enjoyment and non-disturbance clause, limitations on tenant's use of the property and the term, the actual length of the lease, security deposits, which must comply with state law, and a statement as to whether the improvements may be made by a tenant. Fixtures, they generally become the landlord's property unless they are a removable trade fixture. The Americans with Disability Act requires that commercial non-residential property be free of barriers or that reasonable accommodations be provided. Federal fair housing law requires the landlord to allow a tenant with a disability to make reasonable modifications to the premises. Typically, leases will also include a provision that maintenance of the premises will be performed by the landlord in compliance with state law. Also, whether or not an assignment of the lease will be permitted. Whether the assignment will release the tenant of further obligations to the landlord. Whether or not a sublease will be permitted under what terms. Any option may give a tenant the right to renew the lease, the right to purchase the leased property, or the right of first refusal if the landlord decides to sell the property. Recording of the lease may be required by state law. There are 5 types of leases. You have gross lease, where the tenant pays a fixed rent. You have a net lease, where the tenant pays a fixed rent plus building expenses. There's a percentage lease, where the tenant pays rent based on gross sales received. A variable lease, where the tenant pays specified rent increased at set dates. And a ground lease, a lease on the land. Breach of a lease. The remedies for breach of a lease are governed by state law. The landlord may bring suit for possession, actual eviction, or the tenant may claim a constructive eviction if the premises are uninhabitable. The Uniform Residential Landlord and Tenant Act has been adopted by many states in whole or in part, and a revision is underway. Federal fair housing and civil rights laws affect landlords and tenants just as they do sellers and purchasers. Property managers, that's an individual or a company, and they act as a general agent of the investment property owner. They administer the objectives of the owners, like generating income, preserving and or increasing the property's value. What are the licensing requirements for property managers? Property management functions may require a real estate license or a property management license as provided by state law. In Alabama, a real estate broker's license is required for any person or company that, for compensation, engages in the lease or rental of real estate in Alabama, who offers real estate for rent or lease, who negotiates rental or leasing of Alabama real estate, or who lists, offers, attempts, or agrees to list real estate for rental or lease. A salesperson working under a broker may engage in such activities. However, a real estate license is not required of persons acting as a manager for an apartment building or complex. Property managers may undertake asset management by helping the owner to decide the type of real estate in which to invest, residential or commercial, the best property to purchase, the financial resources necessary to fund the purchase, and the best time to dispose of property. A leasing agent is usually a state-licensed real estate professional working as an independent contractor or property manager on a commission basis. A corporate property manager is usually an employee of the corporation. Management agreement and plan. Describe the property. Define the term of the agreement and how it can be terminated. Define the manager's responsibilities, including the extent of the manager's authority. State the owner's responsibility for management expenses. Indicate the manager's compensation. List the financial reports that the manager must make. Require that there be compliance with all applicable federal, state, and local laws by all parties. And provide an operating budget, which is a one-year projection of income and expenses. Building managers set rents that are enough to cover fixed charges and operating expense and a fair return on the owner's investment, in line with prevailing rates in comparable buildings, and a reflection of the current vacancy rate of the property. Rents are determined at monthly rate per unit for residential property and at a monthly rate per square foot for commercial property. A building manager selects tenants within a certain parameter while complying with all applicable federal, state, and local fair housing, anti-discrimination, and equal opportunity laws. Commercial tenant considerations typically include the suitability of a building in terms of size, location, and amenities, compatibility of the prospective tenant with the building and other tenants, and the availability of space for expansion if necessary. When collecting rent, the building manager should establish a firm and consistent collection plan for rents. Lease agreements should spell out the time and place for payment, penalties for late payment, and bounced checks. Also, cancellation procedures and damages in case of non-payment. Building managers maintain good relations with tenants with track and uniformity expressed in effective communications, fair and consistent enforcement of the rules, prompt attention to maintenance and service requests, and careful record keeping with attention to lease renewal dates. To find and retain reliable tenants, a building manager must devise an effective marketing strategy. Property maintenance includes preventative maintenance, timely repairs or corrective action, as well as routine activities that will help preserve the property and enhance its desirability to tenants. The environmental concerns that require the attention of the property manager include the disposal of hazardous waste, lead-based paint disclosures for residential property before 1978, building-related illness, which is a clinically diagnosable disease or condition such as Legionnaire's disease or an allergic reaction that's caused by a microorganism or substance demonstrably present in the building. The abbreviation is BRI. Compare this with sick building syndrome. That's a condition affecting office workers, typically marked by headaches, respiratory problems that are attributed to unhealthy or stressful factors in the working environment, such as poor ventilation. Americans with Disability Act, that's federal laws affecting property management, which include the following. The Americans with Disability Act has Title I and Title III. Title I applies to employers with 15 or more employees and provides for employment of job-qualified applicants, regardless of disability, with reasonable accommodations. Title III prohibits discrimination in commercial properties and public accommodation and requires that access to facilities and services be provided when reasonably achievable in existing buildings, with a higher standard for new construction or remodeling. Equal Credit Opportunity Act, again, it prohibits lenders from denying loans based on persons' race, color, religion, national origin, sex, marital status, age, or receipt of public assistance, and additional protections may be added by state or local laws. The Federal Fair Housing Act, remember, that prohibits discrimination in the sale, rental, or financing of housing based on race, color, religion, national origin, sex, familial status, or disability. Additional protections for individuals may be added by state or local laws. Risk management, that includes treatment of risk by deciding whether to avoid it, control it, transfer it, or retain it. Actor, and focuses on tenant, security, and types of insurance available. The renter's insurance policy that covers renters' personal property is the HO4 policy.